In almost every juvenile defense case I take, the parents and the child always ask, was I entitled to my Miranda rights? And did I have the right to have a parent present when I was questioned by the police? The question is a lot different than as it pertains to adults, as to whether the child was in custody and whether they were truly being interrogated. Those are the two questions that must be answered to determine whether someone is entitled to their Miranda rights. Well, first, whether the child is in custody. For adults, being in custody generally means being placed in handcuffs, being in the back of the police car, being at the station, things of that nature. But for children, it counts as being in custody when they're in the principal's office. For example, the U.S. Supreme Court has decided that that is enough to constitute custody as it pertains to a child. The child does not feel that they were safe to leave the principal's office, to not answer questions, and so therefore they are entitled to their Miranda rights. And so as it pertains to those Miranda rights, the question becomes, well, is a parent entitled to be there before my child is required to answer questions as to what they did or did not do? Well, again, there's a totality of the circumstances approach that the courts look at as to whether a parent was entitled to be present. A lot of factors are taken into account, but just to name a few, it's the child's age, their mental health, their knowledge of the juvenile of Miranda rights, and whether or not they've read or seen those before. Those are all questions that a judge may ask in determining whether a parent should have been present before your child was questioned. And so, if the court found that your child was in custody and that he or she was being interrogated by the police or the resource officer or the principal, and they're trying to use that video evidence or written statement that your child made against your child as a statement against his interests or an admission of what he or she did. Well, if he was found to be in custody and found to be interrogated, then he was entitled to his Miranda rights, and those statements may be suppressed by his or her criminal defense lawyer through filing a motion to suppress any statements that were made when they should have had those Miranda rights read. Even in circumstances where it is found that your child received his or her Miranda rights, there's still a potential that statements may be suppressed if there's an argument that the parent should have been present because of your child's age, mental health, and circumstances such as those. So it's always important to bring that to the attention of the juvenile defense lawyer for them to be able to look at all the totality of the circumstances and determine whether certain statements or admissions made by your child may be suppressed and excluded from court and being used against your child.